Hello, welcome everybody. Hi, give it back to me. Give us some energy to our panelists. Hi there, that's right. My name is Max Orr. I'm Executive Director for Carolina Public Humanities, the public outreach arm for the College of Arts and Sciences. And it's our job to take excellent scholarship at UNC and share it with the world and create humanistic discussions around all kinds of important topics. And that's exactly what we're doing here today. This time slot, 4:30 to 6, is usually when we do Humanities in Action. And I know several of you have been to some of those talks this semester. And our dear friend, who I'm going to introduce in a moment, wrote us back in the spring saying, hey, I know you do those things at Flyleaf Books. Do you think we could squeeze this in November? And we were absolutely delighted to have this partnership. So this is like, we call this maybe an epilogue to Carolina Public Humanities, Humanities in Action, is this special panel on academic freedom and free speech. A few pieces of housekeeping. One of them is that we have a QR code on that little table there. We would love it if you could scan that on your way out and give us any feedback you have on this program or on any programs you've seen at Carolina Public Humanities. And also we have opportunities there to give us ideas for other programming if you would like. Normally at this time I'd also be telling you about other Carolina Public Humanities events, but this is the last event of our semester. We have one more book group, but so this is our last public event. So we're very happy to have this be, like I said, an epilogue for the whole season, if you will. But if you are interested, please go to humanities.unc.edu, check out what we have coming. We'll have our spring lineup, which is really exciting, coming up. We're going to be working with the PPE, the Philosophy, Politics, and Economics program, for a whole slate of talks here doing Humanities in Action right here at Flyleaf Books, and of course all sorts of other great events. So check that out. Go to social media, all of our Facebook, Instagram, all that good stuff. I don't think we're on Snapchat, but at any rate, go in and line up, sign up, and get involved, as the great Firesign Theater used to say. Okay, well, this is the easiest thing I have to do to introduce a dear friend to Carolina Public Humanities. That is Mary Rose Papandrea, the Samuel Ashe Distinguished Professor of Law. Mary Rose, you have done so much work with us. You've been so willing to volunteering. You've spoken right here in this very room before. Mary Rose has been crucial to discussions around democracy and free speech here at UNC, and this is an absolutely apropos event for you and your interests. So what we're going to do is turn it all over. My job is so easy today because I'm going to turn it over to Mary Rose Papandrea to introduce David Rabban and Keith Whittington. But let me just say to you two scholars, thank you for coming and joining us here at Carolina Public Humanities at UNC. We are honored to have you. And Mary, you can tell us more about these distinguished people. Take it away, Mary Rose Papandrea and our panelists.
Thank you so much for allowing this event to take place. Before I introduce them, I want to say that the law school is having a symposium on Friday. These two gentlemen will be participating. The topic is free speech in universities. There is a lot happening in this space. So we have panels on student speech rights, faculty and academic freedom, and institutional neutrality and leadership challenges. We have Liz McGill and others coming. It's going to be fantastic. So it's Friday, 8:45 to 3:15 at the Carolina Club. So let me introduce our speakers. They are both here. They flew in early to meet with you all, but they will be speaking on Friday. To my left is David Rabban. He is the author of a new book, Academic Freedom: From Professional Norm to First Amendment Right. I understand that you may not be able to buy it today, but you can order this book and Keith's book from the bookstore. He is the Dahr Jamail, Randall Hage Jamail, and the Robert Lee Jamail Regents Chair in Law, Distinguished Teaching Professor. He served as counsel to the American Association of University Professors for several years before joining the Texas faculty in 1983. He later served as its general counsel and chair of its Committee on Academic Freedom and Tenure. So I think he knows what he's talking about. His teaching and research focus is on free speech, academic freedom, higher education on the law, and American legal history. Thank you so much, David, for joining us. And to my right, I have Keith Whittington. He's written more than one book, but the one that is the most recent is You Can't Teach That! The Battle Over University Classrooms. Also, I'm sure the library here would be happy to help you order a copy of this wonderful book. As of this past summer, he is the David Boies Professor of Law at Yale Law School, where he has launched the Center for Academic Freedom and Free Speech. He joined Yale from Princeton, where he worked since 2006. His teaching and scholarship spans American constitutional theory, American political and constitutional history, judicial politics, the presidency, and free speech and the law. He also serves as the founding chair of the Academic Freedom Alliance's Academic Committee. Before we get started, I do want to tell everyone, and then them, how much I have admired your work. It is, I've just met them today, about 30 minutes ago, for the first time, and I'm a fangirl, so this is very exciting. This is very exciting for me to have the opportunity to talk to these two leading scholars in this space. So these books both span so much, and of course there's a lot in contemporary affairs right now that I hope we'll be bringing into the conversation. We have an hour and a half today together. We will reserve at least 20 minutes for questions. So please, I'm sure you all have questions, and there is literally no one better in this country to help answer the questions you might have on these topics. So I thought I would just start with you, David, and then I'll turn to you, Keith, with a similar question. Can you tell the audience what the goal was in writing this book? Like, what prompted you to write this book and write it right now?
Well, I wanted to try to make sense of the status of academic freedom as a First Amendment right. I've been working in this area, as you've heard, for my entire professional career, so I was familiar with many of the cases. And my impression was that the decisions were all over the place in result, in reasoning. I wanted to try to do my best to, first of all, to read them all, and there are thousands. Now, some you could read very quickly and know they're not worth lingering with, but there are quite a number of significant cases. I wanted to know what the cases were. I wanted to try to classify what the cases were saying, to organize them. And based on that organization and classification, I wanted to develop my own views of what the First Amendment right of academic freedom should mean. It turns out, under current law, academic freedom is clearly recognized as a First Amendment right. But what that right means, how far it extends, how it's justified as a First Amendment right, has barely been explored, as many judges themselves often complain. So I wanted to do the work of organizing the cases, and then based on the organization and what that organization shows about the uncertainty and deficiency of current law, to promote my own view of how academic freedom should be interpreted. And in my view, it should be interpreted as a distinctive First Amendment right, different from the general right of free speech.
Yeah, this is quite an extraordinary, I just have to say, David, just an extraordinary book. It will now become my Bible. I will be keeping it close by at all times. I know some of you are not lawyers. Some of you are lawyers or lawyers to be. There is an extraordinary bibliography. The footnotes that you did, the research you put into this book really is amazing. And so I thank you. And I know many others will thank you for doing this work.
Thanks. I just wanted to say, I wrote it for scholars, but I hoped to have written it in a way that's accessible to members of the general public, and I hope I succeeded in that.
It truly is. I didn't mean to scare people off by mentioning the extensive bibliography. It's just, you can have confidence that it is extraordinarily well sourced, that it does include, if you are interested in further reading, that bibliography you include at the end, where you have a narrative about your sources, I thought was particularly useful for those who are looking for the key articles and books on this topic.
Thank
and
you.
Of course, your work is included. And so Keith, you've written other books and articles. What prompted you to write this particular book?
Yeah, unfortunately, I think we're not hurting for issues arising connected to academic freedom and campus free speech issues more generally. And I've been sort of busily writing about quite a few of them and thinking through both the sort of principles that arise out of the tradition of academic freedom protections, as they've developed in the United States over the course of the 20th century, but also trying to think about the First Amendment implications of some of these particular issues. And this book in particular is motivated by the rise of these state legislative proposals, reflected most notably in the Stop Woke Act that came out of Florida a couple of years ago. They're designed to restrict what kinds of ideas can be advocated or taught within a state university classroom context. And it seemed like a useful and important opportunity to, one, try to think through what, if any, real constitutional limits are there on a state legislature that might want to do that, and to provide some guidance to courts and to others. They're trying to navigate that and think it through. As David suggested, I think it's right that there's a firm grounding recognized in earlier Supreme Court doctrine that there's some First Amendment protection for academic freedom, but what the contours of that looks like, not very well developed at all. And has really been left to lower courts to figure out. And I think it's easy for lower courts and eventually the Supreme Court confronted with something like the Florida statute to get lost a bit in trying to think through how doctrine might be applied in this context. And there's also lots of room to make mistakes and actually draft doctrine that will create real difficulties down the road as we try to navigate academic freedom concerns. So there's sort of an immediate concern of thinking about these kind of state legislative proposals and what kind of constitutional problems are they creating. And I hope also the book then, in addition to sort of grappling with those current policy issues, also provides an introduction to specifically a freedom of teaching in American universities. So there are other aspects of academic freedom protections that are critically important, but this book focuses specifically on thinking about the questions of scope of freedom to teach in universities generally. It gets to this specific context of thinking about state universities. But in order to get there, I want to talk more broadly about the kinds of principles and controversies that had arisen over the course of time, and including the history of what it looked like before there was any robust protection for freedom of teaching in universities. And so the kinds of controversies that are arising in the 19th century and early 20th century, for example, that gave rise to thinking more seriously about we need to provide some protections for teaching, and there are good reasons why we made that turn and wanted to adopt those protections, and reasons that we should not forget about now, no matter how unhappy some politicians might be with some particular things they see being taught in classrooms right now.
I do
One
want
thing
to
I might
talk.
add
Oh,
to
yeah, go
Keith's-
ahead. Yeah.
You know, I didn't start writing my book in response to all the recent controversies about and attacks on free speech and academic freedom from both the left and the right. I wanted to write this book anyway to address, important issues of academic freedom and tenure. And then it just happened as I was finishing my research and writing the book, there's been an explosion of new contemporary issues dealing with academic freedom and free speech. So kind of in a way, what's a problem for the country makes the book I was going to write anyway more relevant. And I discuss some of these current issues in my book, but mostly it's just about the general background and theory.
I did notice that throughout your book, you do bring in some references to the more contemporary issues that you've seen. And before, I do want to talk about the history that you mentioned, Keith. Yeah. Before I do, I want to make sure I'm an equal opportunity gusher about the book. So this book is extraordinarily readable. It also does cover some ground I haven't seen in much scholarship, particularly about indoctrination and compelled speech on students. And of course, we'll talk more about that today. Yeah. But you did have to cover a lot of ground to address the constitutionality or concerns about the kind of legislative proposals that we've been seeing. So we have so much to talk about. I do want to start at the very beginning. So you both, there's a lot of overlap in these books, and one area of overlap is discussing the history of universities in the United States particularly, and the academic freedom doctrines. And maybe I'll start with you because You can talk about just the general history, and then David, of course, you, with your affiliation with the AAUP, you have a detailed history of the development of the AAUP and some of their first principles in the 1915 and forward. So get ready.
Okay.
I'm gonna, and of course, you can supplement his history as well. But if you don't mind, I'll get started with you.
Yeah, I mean, so the book does talk some about the early history of the AAUP and the formation of these principles and commitments that arise out of the AAUP's work, in particular in the early 20th century, in part because it provides the principled core that I think any kind of constitutional doctrine relating to academic freedom needs to draw on, and it provides the kind of history and practice that help make sense of this. But the book really, in thinking about this freedom of speech as it's arisen in the United States, tries to begin, in some ways, in the cases before the AAUP was forming that helped motivate the AAUP to form in the first place, the kinds of controversies that were arising, which I was sort of vaguely aware of, but spent more time researching for the purpose of the book of, for example, the kinds of legislative as well as private interventions in university teaching of human evolution. In the 19th century, we tend to remember in particular the Scopes monkey trial and the kind of legislative restrictions on teaching of human evolution in public schools, K through 12 schools. But those same statutes were generally written to apply to state universities as well. And there were likewise controversies around state universities, both at the time that the legislation was being drafted and then also the sort of fight to whether or not to adopt that across a range of states, and then the subsequent existence of those statutes over time. And that's been sort of one source of conflict that had arisen over time, but one of many, and a wide variety of different kinds of topics that would anger sometimes important government officials and policymakers, but often as well would anger donors and alumni and others who could put pressure on university to try to shut down teaching. And again, I thought in part it would be useful for purposes of the book, especially for a broader audience, to try to remind people that if you go in the direction that advocates of some of the current legislative proposals are suggesting, it opens a very wide door to restricting teaching of subjects in classes that might be controversial. And that wide door will allow a wide range of potential restrictions to come in. So it's worth remembering not just sort of our current controversies and the current things we're worried about, but the wide range of different controversies that have arisen over time, and the many things people get upset about as a consequence of their being talked about in classrooms, and as a consequence the importance of maintaining fairly high protections for a classroom space where you can talk about those controversial ideas, so that you don't have to worry so much that this particular thing that may not seem very controversial right now won't become controversial 5 years from now or 10 years from now, and suddenly find yourself the target of a campaign to say you're not allowed to teach that in public universities or even in private universities more generally.
So this might be an unfair question. You could just tell me, we can talk about it at dinner later. But do you think that given that academic freedom doesn't have a long history, that this court, if ever asked about it, and of course maybe jumping ahead, but this court might be unlikely, or at least some members of the court would be unlikely to recognize it? How do you think they might think about this? Because you are an expert on a lot of things, and this constitutional interpretation also is one of them.
Yeah, so I mean, part of the book is to try to make as strong of a case as possible in ways that I think would be compelling to current judges on behalf of fairly robust protections for academic freedom in public universities that have real implications for legislation like the Stop Woke Act, at least. Although, as you know, there are aspects of that act and also sort of subsequent generations of these kinds of policy proposals that are floating in state legislatures, where I think the First Amendment issues become even more complicated, and actually I think some of those are probably less vulnerable to being struck down than potentially the Stop Woke Act is. But broadly, I'm cautiously optimistic. I think that that the current court can be brought to a point of recognizing that the kinds of interventions that Florida is advocating and the kind of sweeping constitutional argument that Florida is making in order to defend its current position would be not only bad for universities, but would severely undermine an important strand of First Amendment doctrine that arose in the mid-20th century, and it arose in the mid-20th century for a reason. And so I can easily imagine some of the justices not going along with that. So I'd be a little surprised, I think, if you had a unanimous opinion where all the judges were willing to sign on for that view. But I think there actually might be a majority on the court that can be sold on this kind of argument.
Okay, great. Well, we'll come back to some of the perversions of the
I thought you were
document.
saying we come back after the court hears this case and remind me of what I said.
I mean, I'm not sure anyone's quite eager for that, but you know, I take some solace in what you said. The court has generally been protective of First Amendment rights.
On the whole, it's a very First Amendment friendly court and a very free speech friendly court. Even its most conservative members tend to be quite friendly to free speech. And I think that'll give us some real hope. Likewise, there are justices serving on the court who have experience in universities and as a consequence appreciate the kinds of challenges associated with the possibility of restricting teaching in a university environment. And so I think there's space there, but on the other hand, there's certainly currents, both political currents in terms of unhappiness with some of what people are seeing on university campuses that might affect the justices. And likewise, it's worth recognizing the kind of academic freedom protections that the court recognized in the 1960s are not grounded in the kind of originalist argument or historical argument that the court now tends to prefer. And so one, I think, open question for the current court is, do you revisit the conceptual foundations of a lot of free speech doctrine, or do you take that for granted? And so far, I don't think there's much appetite on the court to revisit those fundamentals. But some lower court judges are starting to suggest, well, shouldn't we do the same kind of originalist analysis when it comes to free speech that the court's telling us we ought to do on the Second Amendment, for example? And the book does not take on that task.
No, I know.
Trying to say how to build that, but I think that would be, I think it can be done. But it's a huge challenge to lift if the court really insisted on these kinds of Warren Court doctrines that are free speech protective. We should open that all back up and revisit those and rebuild them from the ground up. This book sort of assumes, okay, take those as a given.
Yeah.
How can we work with those,
Right,
and where
right.
can they take us?
Yeah. Thank you, though, for answering my question, because I've been curious about your thoughts on that. Okay, so back to you, David. So you spent some time talking about the formation of the AAUP and some of their principles in the 1915 document that they issued. I'd love for you to walk through whatever you want to say to this audience about the creation of the AAUP and then talk about their principles. I thought it was such an interesting part of your book where you talk about what their principles, how they came to their principles, and then we'll examine ways you don't actually 100% agree.
Right. So when I started working on this book, I didn't think I would spend much time on the AAUP's 1915 Declaration, which was its foundational document and is the basis actually for many existing university regulations today. I thought I was going to focus on the legal and constitutional interpretation of academic freedom. But as I was working on the book and reading all these cases, which were intellectually so unsatisfying, even if sometimes the results seemed right, I realized, I was very familiar with the 1915 Declaration through my work at the AUP and through my previous scholarship. I realized that the justification for academic freedom in the 1915 Declaration is much more convincing than any language in any judicial decision at any level. I therefore felt it was important to kind of recreate this justification. And I came to the conclusion also that the AAUP's justification for academic freedom could also fit into a First Amendment justification for academic freedom. As I say that, I want to emphasize my view that legal scholars and judges way too often try to shovel in their policy preferences into analysis of constitutional law. I often find that unconvincing, and I resist it. But sometimes, I hope not only because they're my policy preferences, but sometimes policy preferences do fit into legal categories of interpretation. And here's why I found the AAUP justification for academic freedom so convincing. And because it's convincing, I wanted to elaborate its background in at least a chapter-length treatment. Okay. The basic justification for academic freedom in the 1915 Declaration is that professors cannot perform their jobs in the interest of society at large unless they have academic freedom in their research and teaching. And the argument is that the expert academic background of professors allows them to investigate, write about, and disseminate expert knowledge to the entire society, that's a societal benefit. And that professors cannot perform that function if they can be disciplined or even fired for reaching academic results accepted by the academic community, but which the broader society, especially including maybe presidents and boards of trustees or state legislators or state regulators, find offensive, right? If you can be punished for reaching legitimate academic conclusions that offend others, you can't do your job. So the AAUP's basic justification for academic freedom was it's necessary for professors to do the job they're hired to do. And I find that extremely convincing, very convincing. Also, in my view, protecting the production and dissemination of knowledge is a core First Amendment value, recognized in many decisions, not just in cases involving universities. It's also a core constitutional commitment outside the First Amendment, including the original protection of copyright in the Constitution, is to protect the production and dissemination of knowledge. So the justification for academic freedom by the AUP fits a fundamental First Amendment value. And here's where Keith and I might disagree a bit. And
Oh, good. Let's get some.
We agree on so much. We do agree on so much,
You do.
including, as you see as a reader of both. So in my view, it doesn't make sense to have a First Amendment right of academic freedom if academic freedom means the same thing as free speech. If it means the same thing as free speech, why have a separate right? It doesn't make sense. So in my view, to make a convincing argument for a distinctive First Amendment right of academic freedom, you have to differentiate academic freedom from general free speech rights, number one, because if you can't do that, it's over, there's no point to it. If you can differentiate academic freedom from free speech, you then have to connect it to the First Amendment to argue for constitutional protection. Whereas Keith, I think, more wants to work, maybe for prudential, pragmatic reasons, within the existing constitutional law of free speech, without focusing as much as I do on a separate, distinctive right of academic freedom.
I'll let him-
Keith,
why don't
Keith
we
can
let
respond
him
to that in a
address
minute,
that?
but,
What
but
do you
let me
think
let,
about
let me
that?
just follow
Oh,
through
sorry,
and
you have
say.
time to formulate your response.
So
Keep
to me,
going,
this
you
is
still have the floor, David.
What's distinctive, why it's not, free speech is the right, at core, for citizens generally to speak about matters of public policy in a democratic society. It's an equal right of all citizens to speak about public affairs. The people have the sovereign power. That's the core of the general First Amendment right. And professors should have that right too, of free speech, but to the same extent as everybody else. The First Amendment right of free speech basically is an equal right of all citizens. And sometimes judges resist recognizing academic freedom because it seems to give special rights to professors. My view is, yes, it does. But it does for a very important reason, which I've already mentioned, which is in society's interest. Professors need this special protection against being fired for ideas that may offend their employer or their funders. They need this protection to do their job in the societal interest, to search for and disseminate expert knowledge. They can't do that job without academic freedom. By the way, academic freedom also comes with certain limitations, because if you speak within your professional expertise in a way that does not meet professional standards, I would say as determined by peer review, you can be disciplined, whereas a member of the general public cannot be disciplined for foolish speech about an issue. So that's my view of how the First Amendment right of academic freedom is different from the First Amendment right of free speech, but also that academic freedom comes within the First Amendment because the First Amendment has a central value of the production and dissemination of knowledge, not just the protection of political expression.
Okay, there's so much. There's so much. First, I want to highlight. You're still working over here on your response. Okay. David, one thing that might be important for the audience to understand is this declaration, the 1915 principles, came before the Supreme Court.
Very important.
Really said anything much about
at all.
Yeah, really, about the First Amendment. That did not happen until 1919, and then incorporated in 1925 to the state. So so it's predated, but even more so, these principles apply equally to state universities and to private
under the AUP.
Under the AAUP, and so I just thought it might be worthwhile to make sure we're clear on that, because that is important and is very relevant when we start talking about the Constitution and constitutional protection. So you could just talk a little bit about that.
So I should reiterate.
Yeah.
The Supreme Court did not recognize academic freedom as a First Amendment right until 1957. That's late in the day. There's been a lot of development since then, but academic freedom was not recognized as a First Amendment right before 1957. Whereas, there was a lot of discussion of academic freedom as a professional norm. I don't agree with everything the AUB said about, should I get into this?
I think we have Keith on deck here, so don't get into that just yet. Just talk about public versus private.
Okay. So many lawyers forget about this, and certainly members of the general public don't focus on it. The First Amendment applies only to action by the state, right? It does not apply to action by private individuals. Some people think, I have a First Amendment right. My employer can't do this to me. It's a First Amendment right. No, not if your employer is a private employer, right? It's a First Amendment right against the state. So what does that mean? It means that the First Amendment protects professors, arguably universities, against legislative intervention, which Keith has been referring to, against executive intervention, right? That protection applies to professors at private universities too, because it's action from the state that affects them. Right? It does not apply, and the First Amendment applies to interaction between professors and administrators and trustees at public universities. It's a public university, there's the state action. The First Amendment does not apply to the interaction between professors and administrations, boards of trustees at private universities. So to take our local example, you're protected by the First Amendment because you teach at the University of North Carolina, a public institution, and you could bring a First Amendment lawsuit against your dean or the Board of Regents.
I'm not going to, but I could.
Right.
Good to know.
If you teach at Duke, you cannot. You could bring an action against a public official, against legislation. You cannot bring a First Amendment lawsuit against administrators or trustees because there's no state action. Is that clear?
Yeah.
Okay. But I want to add one more thing that's very important. Many private universities voluntarily accept for themselves the requirements that the First Amendment imposes on public universities. So Duke might decide to apply the First Amendment in the way that the University of North Carolina must, because Duke doesn't want to be perceived as affording less First Amendment or academic freedom rights than the University of North Carolina. And just to take an example from my own experience, I was a student at Stanford Law School at the height of anti-Vietnam War protests. That's how old I am. And there was a very eminent English professor. He was a scholar of Melville, undisputed one of the leading scholars in the world, who was also an anti-war activist. I could say more later if you're interested. But he was accused, and it wasn't implausible, of inciting to riot in an anti-war speech. Soon after which, students trashed a university building that he had pointed to. Okay. In bringing dismissal charges against this professor for incitement to riot and to violence, which is not protected by the First Amendment, the Stanford administration told the faculty review committee, we want you to apply the constitutional standard of incitement that applies to public universities. We voluntarily do at Stanford what Berkeley must do. Now, not every private university does this, but many do. So that kind of weakens, to some extent, the private-public distinction, which is important as a matter of formal law, but is blurred in practice for reasons I've indicated.
Great. Thank you so much for doing that. Now, okay, you've had some time. In answering David's suggestion that maybe you see it all within the First Amendment framework, I thought maybe I'd give you another question you could fold in there, is talking about the Garcetti case, maybe, because I feel like that might be relevant to your
Yeah,
answer.
no, absolutely. So, so I guess just to start with the question of sort of how much I try to build on generalized free speech doctrine as opposed to thinking about something specific to academic freedom. I think it's true that David's project tries to suggest more radical reforms in existing doctrine than what I've tried to do. I've tried to instead see how far can we take existing doctrine and not ask the courts to make as heavy of a lift then of having to say, okay, look, you've got to just rewrite some of this stuff in a more dramatic way. Instead, the question is, if you take existing doctrine more or less as given, how can it be construed, and how do you work out the nuances of it and the implications of it in ways that are fairly protective of free speech? And partially, I think, in order to make that doctrine work in a meaningful way in academic context, I think you need to integrate some crucial norms out of the larger academic freedom tradition as a professional practice and integrate it into constitutional law. So to the extent to which the court says there is an academic freedom principle that's protected by the First Amendment, I think that has to effectively reference these professional norms. And in particular, two crucial norms, one of which David just mentioned, one of which I think I want to make a little more explicit than what may have been discussed so far. So the one that he referenced in particular is there's a, unlike our general understanding of free speech commitments broadly, there is a professional competence expectation when it comes to, in particular in this context of thinking about teaching. Quite properly, university officials, including state university officials, have an interest in making sure that when a professor is teaching the classroom, they're doing so in a professionally competent way. And so they can't convey falsehoods and misinformation, for example. They're fully protected in a broader First Amendment context, but we would not say, or I don't think should be said, to be protected by First Amendment principles in the context of a university classroom, even if we think some university principles ought to apply in a university classroom, right? So we need to integrate in some sense of professional competence as being part of the background conditions under which academic freedom principles are recognized in that context. The other principle that I would want to also make more explicit is a germaneness requirement. That is, we expect professors in the classroom not only to competently be teaching their subject matter, but to actually be teaching their subject matter and not to be doing other things. And courts, I think in particular, the competence issue, I think, has not arisen quite as much in the lower courts, although you see it sometimes, and I think courts are not as clear and as careful in thinking about the competence issue as they could be. But I think also the germaneness issue is often sloppily handled by courts, but has to be taken extremely seriously, I think, if you're really going to get serious about trying to think about how academic freedom principles apply in this context. That is to say, it's sort of a natural for judges to think, well, if once you've said that there are First Amendment protections that extend to a professor in a classroom, then if the professor is talking about core things we care about from a First Amendment context, for example, they're talking about the election, and they're talking about the political candidates in the election, then that's core First Amendment protected speech in all kinds of other contexts. And yet we might well think that's inappropriate in the introduction to chemistry classroom. And university officials can quite rightly step in and say, you're not supposed to be spending your introduction to chemistry class talking about how unhappy you are with the election outcome in that classroom. And university officials can quite properly come in and intervene and say, you got to stick to the subject matter of the class. I think the courts, one, have to then think about how can we embrace that kind of principle and still make sense of the idea that there's some kind of First Amendment protection here. And I think borrowing from existing professional norms and how we've conceptualized academic freedom over the course of the 20th century would be very helpful. But it requires, I think, judges to be more self-conscious about how they're borrowing from those professional norms and how they ought to be integrated into constitutional law than they frequently are in general. So the Garcetti case poses, I think, one of the really serious challenges to thinking about where we stand relative to academic freedom protections. One of the complications, I think, of thinking about sort of where are we with constitutional doctrine relative to academic freedom is we get these cases in the 1950s and 1960s that say some very nice things about the First Amendment has an interest in academic freedom. And then and then the court sort of stops talking about it. And it's sort of left to the lower courts mostly to sort of subsequent to those cases, we get a rise of two really important strands of doctrine that have implications in this context, but how these lines of doctrine ought to be reconciled has not been thought through very carefully by the court and will now have to be thought through carefully as they're dealing with things like the Stop Work Act. So one of these is so-called government employee speech doctrine. Broadly speaking, what kinds of First Amendment rights do government employees have relative to their governmental employer more generally? And the court has both recognized that there are rights that individuals on the job have or government employees have broadly, and then have also recognized there's some real limitations here. And Garcetti is the most recent intervention by the Supreme Court on that front, and specifically emphasizes the idea that when you are speaking as part of your professional duties, so you're not posting social media posts at night on your own time, but when you are performing your professional duties in the governmental workplace, the government has a great deal of managerial control over that speech activity, which may include the capacity to create, as the court sometimes like characterize it, adverse employment consequences for you if a supervisor is not happy with the work product. That would be devastating to any notion of academic freedom because, of course, the core things that professors are doing, both in scholarship and in teaching, is performing their professional duties as professors as such. And in the Garcetti case, this is called to the court's attention by Justice Souter, and Justice Kennedy says, oh yeah, we'll deal with that later. And so we will not say whether or not there is an application here to thinking about scholarship and teaching. We will save that problem for a later date.
And just to, because the audience may not know this case, it was not a professor case. It involved
was
a
not a professor
prosecutor.
case.
So that's why they
Right.
were able to just say, oh, for another time.
Right. So a lot of these government employee cases have not been cases that have arisen in the context of faculty. They've arisen in other contexts. This was a government attorney context, right? So government attorneys writing memorandum inside government offices, dealing with matters of public affairs and public policy, sort of core kinds of things First Amendment cares about, and the court quite reasonably, I think, said, just because you're writing about public policy issues in your governmental memoranda does not mean you're insulated then from repercussions of what you say from your supervisors on the job, for example. But if you don't carve out some kind of academic freedom exception, if you don't say professors are just different than all kinds of other government employees, then there's nothing left of academic freedom as a constitutional protection. So part of the lift I think you have to do at this point is persuade the court that the so-called Garcetti exception for academic freedom ought to be a real thing and has to be preserved, and it won't eat up the entire rest of the court's concern about we need to be able to supervise what government employees are doing more generally. Just very briefly to say the other sort of line of doctrine that sort of developed subsequently that overlaps with Garcetti ultimately is so-called government speech doctrine, which is to say the court has increasingly recognized that the government, of course, can convey its own messages in the public sphere, and as part of the process of conveying its own messages in the public sphere, it hires people to convey those messages. So Florida's position, as it tries to defend the Stop Woke Act, is state university professors are the hired comms people for the government. The government just hires state university professors to convey the governmental message. So everything that happens in a state university classroom is ultimately the government's speech. It's not the professor's speech. And as a consequence, the professor has no legitimate First Amendment interest in that speech, and the government can tell them what they should and should not say in that classroom context. And that's probably the right answer in lots of other government employment contexts and lots of other governmental agency contexts. And so again, it goes to this question of to what degree are universities different and how do you constitutionalize that in a meaningful way? And what are the effective boundaries of kind of trying to constitutionalize that kind of right? So I think there's going to be some hard things to get judges to really swallow when confronted with this argument. But on the other hand, I think one thing that's nice about the Stop Woke Act setting this up and nice about how Florida is defending the Stop Woke Act is that it's put these issues in very stark form. So Florida's claim in court is really not just there's some very specific ideas, they're way outside the bounds and can't be protected. Florida's core claim in court in defending the Stop Woke Act is everything state university professors say in a classroom can be controlled by the government. And it doesn't matter what the specific content is on that, no matter how mundane it is. If the government doesn't like it, they can make you stop saying it or fire you for engaging in it. And so that's going to force the court, I think, to face some very stark choices about, okay, what kind of protections we need to have going forward for state universities, and should we really think the state universities are just an extension of the governor's office or the state legislature, and the state legislature could just tell state university professors what they can and can't say in a classroom context. And notably, right, there's nothing special about classroom context there. If you could do that in the classroom context, constitutionally speaking, that should equally carry over into the scholarly context as well. right? So the court has married the teaching with the scholarship, and you can easily imagine the same kind of argument would play to say your scholarship also is a form of government speech, and if the governor doesn't like what you're doing in your scholarly work, they should be able to control that also if you're a state university employee.
So, go ahead.
May I?
Yes, of course.
So Keith and I think almost totally agree about how these cases should be decided, what the results should be. In my opinion, and some of this I realize it's inside baseball, it's law stuff, but it's very important to addressing these issues. Keith's comments just now, to me, underline how important it is to have a distinctive theory of academic freedom that's different from free speech. How do you import these academic freedom concerns into the First Amendment unless you have this theory of why universities and professors are different? And I want to go back to the Garcetti case, public employee speech jurisprudence. I was general counsel of the AUP when the Supreme Court agreed to hear the Garcetti case. And I felt part of my job as general counsel was to look at every case the Supreme Court agreed to hear and make a judgment about whether that case could have implications for academic freedom and for professors' free speech rights. As Keith said, this was a case involving an assistant district attorney, no professor. But the question was, does the First Amendment protect public employees when they're speaking pursuant to their official duties? I said to myself, oh my God, what are the official duties of professors? At the core, it's teaching and scholarship. The official duties test, if adopted, by the way, the Ninth Circuit, the lower court, rejected the official duties test, but then the Supreme Court takes the case. Why? To overturn it. That was obvious. And I told the leadership of the AUP, who had to approve a brief, I said, if this view is upheld by the Supreme Court, that there's no First Amendment protection for speaking pursuant to official duties, it's the end of academic freedom as we know it. We have to write an amicus brief in this case, and we have to point out, so first we should oppose the official duties test, but we should also say, justices, please, even if you apply this official duties test, don't apply it to professors. The result would eviscerate First Amendment academic freedom. I don't know whether Justice Souter picked up on this because of our brief. In my more immodest moments, I like to think so. But it doesn't matter where it came from. He got the point. And because he dissented on this point, as Keith said, the majority opinion, it was 5-4, said, well, you know, some issues have been raised about applying this test to the teaching and scholarship of professors, but this case doesn't involve a professor. We don't have to decide now. And in many subsequent cases, there's been debate about whether there is a quote-unquote academic freedom exception to the Garcetti case. And courts have come down differently, sometimes recognizing one, sometimes not. You can't argue for an academic freedom exception unless you have a theory of what academic freedom is and how it's different from free speech. Okay. In employee speech jurisprudence, there's a concept called matter of public concern. To be protected as a public employee in your speech, it has to be about a matter of public concern as opposed to merely about a matter of private concern. Okay, that makes some sense. But numerous lower court decisions have interpreted core faculty speech that should be protected by academic freedom because it contributes to the production and dissemination of ideas as private speech. So one court dismissively said, well, this professor is just involved in quote unquote abstract theorizing. There's no public interest in that. It's not a matter of public concern. We don't protect it. But academic freedom would and should protect that. Or the faculty member complained to the administrator, like in an attempt to make the university better. That's a private concern within the university, not a matter of public concern. First Amendment law asks the wrong question about the academic speech of professors. It should be about whether it's a private concern or a public concern, or within official duties or outside official duties. The issue should be, is this expert academic speech that contributes to the production and dissemination of knowledge? And if it does, it should be protected and limited on that ground. So I wanted to add
Oh,
that.
thank you. I mean, there's so much here. This framework, I agree the framework just is not, it's not a great framework, period,
True.
for all government employees, but especially not so great for professors. So, you know, time is flying. And one thing I want to make sure we talk about is the power that the state does have, because I think I was struck reading both of your books that although you're both robust advocates for academic freedom, you both recognize that the state does have some power. And again, we are talking about the state's power over its own public universities, not over any private universities in the state. So that is a big difference. So you were saying I could sue UNC for my First Amendment right, but it also means the state does have some robust power. And maybe you could start, you know, just because you do attack the Woke Act, but you're careful to say there are some things that a state could do. And maybe to give you one example, here at UNC, we now, the state requires like a civics requirement for all UNC graduates. So that, for example.
Yeah, no, well, unfortunately, we're getting a lot of for examples, and they're continuing to be developed. And I think each one raises its own sort of interesting set of questions that have often not been very well thought through, not only from a constitutional law perspective, but also I think sometimes not from a very broad academic freedom perspective, and need to be carefully thought through. So just take one question that sort of comes out of the Stop Woke Act itself, and is going to be particularly salient from sort of the next iteration of the Stop Woke Act. So the Stop Woke Act it borrows from Donald Trump's executive order relating to divisive concepts that was originally applied to workplace training in the federal government, and identified a whole set of things that shouldn't be included in workplace training. And then it got built out from there and applied to workplace training in state governments, but mostly by Florida initially, but also by some other states, and then applied to K through 12 educational context, and then applied to higher educational context, right? So there's a particular list of ideas that they particularly don't want included. Well, then the question is, okay, how do you ban those ideas specifically, and what about the ideas that are going to be restricted? And the law, the Stop Woke Act, as it winds up being passed in Florida, has sort of two kinds of components. So one has a sort of string of words about how you might talk about this in a classroom. So these ideas cannot be advocated, promoted, and a couple of other things, and about how it can be taught. And again, Florida has now taken the posture that this is extremely expansive, but one more narrow reading which is sometimes was pitched when the law was being passed, was an argument about, well, you're allowed to objectively teach certain ideas, you're just not allowed to advocate those ideas, right? But one sort of component of this is, how do you present certain kinds of ideas in the classroom? The posture as it's made its way through the court is to sort of assume that the law is actually very expansive in this regard, really. So any kind of positive statements you might make about these ideas is sufficient to trigger the law. But the second component, which has sort of been ignored mostly as it applies to the Stop Woke Act and sort of just lumped together with the rest of it, but has now been separated out in further iterations of similar kinds of bills that other state legislatures are thinking about, is a ban on professors compelling students to believe certain ideas, right? So you can't promote certain ideas in the classroom, and you also cannot compel them to believe certain ideas. What's not explored at all, and it was not all clear, is what does it mean to say you're not allowed to compel students to believe ideas? So one thing I try to explore in the book a little bit is try to unpack what would that actually mean in practice. And in part, it does connect up to what is a very core feature of constitutional law relating to the First Amendment, which is a ban against compelled speech, which comes out of the flag salute case, right? So when West Virginia public schools in World War II, as did schools in lots of other states, required students to say the Pledge of Allegiance and salute the flag. This comes up by Jehovah's Witnesses to be a constitutional challenge. They can't compel us to say the Pledge of Allegiance, and the court says that's right. Ultimately, actually, they have to reverse themselves. So first they say, no, you totally can compel them. And then they come back and say, no, you can't compel them.
Like a year later.
Right, yeah, literally like 2 years later, they come back and reverse the case and say, no, forget it. You have a right against engaging in compelled speech. And this sort of becomes sort of bedrock principle. Of course, we all know you can't compel people to say things they don't want. That's a core First Amendment principle, and there's all kinds of flowery language in the opinion explaining why this is important. Crucially, though, in the educational context, of course, we require students to say things all the time. We're constantly compelling them to engage in speech they don't want to do, right? You have to do your homework, you have to say certain things, and moreover, you may have to say specific content, right? So I may require a student, write me an essay from the perspective of critical race theory, justifying this kind of conclusion, right? Because part of the exercise is to get students to understand the content, be able to show they understand the content, and moreover, to be able to work with those concepts in particular ways. That's part of what we do routinely in education. So how do we take the logic of the compelled speech doctrine and actually apply it in a meaningful way across the range of issues that occur in the classroom? And what does that mean for these kinds of state legislative language that says things like, you can't compel students to believe certain things? I think that the implication of trying to work that through is there is a range of activities professors might engage in a classroom context that I think already are run afoul of academic freedom norms. That is to say, there are things professors might try to do in the classroom that are not properly protected even by our professional norms of academic freedom and under existing academic freedom policies that would also be captured by this. But there's a whole set of things that probably are not, and really we haven't thought through very carefully, more generally. And so there's just a lot of gray area surrounding this question about what does it mean to ban compelling people to believe things, or as the language in some of these statutes or bills suggest, indoctrinating students in various ways. We just don't know what that means in practice. And I think the First Amendment challenges to that kind of language is actually harder to make out. And would be tougher to defend. But then in addition, you've got these other kinds of legislative interventions coming down the pike. So Indiana, for example, has now adopted an intellectual diversity bill that mandates that faculty present students with a range of different views and opinions and perspectives in their classroom, and uses tenure as the mechanism for enforcing that. And so the Board of Trustees is supposed to take into account whether or not faculty are supportive of free inquiry and pluralism in their teaching when making decisions about whether or not to promote faculty and award them tenure within the university. And this also gets tied to a post-tenure review system, so you can go back and revisit tenured faculty on this front as well. I have a law review article coming out about this. I think it's all kinds of problems from a practical perspective, and implementation perspective. It has real academic freedom threats. I don't think, though, that necessarily is going to be very open to a lot of First Amendment challenges. So I don't think it has the same kinds of problems that Stop Woke Act does. And then you also get these kind of legislative interventions that are rising now about, do you have to, and what should be in general education requirements in universities? If Florida doesn't want universities to include sociology, you can strip it out.
Yeah.
Can you require some content in a civics requirement, as they're doing in North Carolina, for example? There's now new pressure in Texas, where the legislature has now pressured Texas A&M to cut off a bunch of curriculum programs, including a new women's studies minor that had been approved by the university, and then they're now backtracking on and withdrawing under state legislative pressures. Again, I don't think there's going to be easy constitutional challenges to a lot of those things, even if they violate a lot of our traditional assumptions about how autonomous universities ought to be from political influence.
Yeah, would you like to add something on that?
A few things briefly. So Keith and I agree on a lot of this as well. It is clear, in my view, that the Supreme Court has recognized an institutional right of academic freedom protected by the First Amendment. The Supreme Court has been clearer about that institutional right of academic freedom than it has been about the faculty right of academic freedom. So there is that right. But also, it seems to me, the state has some legitimate interest in regulating what goes on in its own institutions, a greater right than the state has in regulating private institutions. And to that extent, states have less institutional academic freedom than do private universities. Where do you draw the lines? That's the tough part. So what's easy for me, and I think Keith too, Texas has a requirement, a legislative requirement, the University of Texas must teach American history. I have no problem with that. Okay, I do have a problem, and I think it's a constitutional issue supported by the early academic freedom cases. If Texas says, right, when you teach American history, you must include this interpretation of the Civil War, or you can't include that interpretation of the Civil War. That is legislative interference with the intellectual life of the university. The initial cases that recognized academic freedom as the First Amendment right of professors involved state attempts to simply ask about, in one case, or regulate how teachers can teach. And those state claims were rejected by the United States Supreme Court. So I think there's hope. It goes back to what you were saying earlier, Keith, that a current case in the Supreme Court, in answer to your earlier question, would recognize certain rights of academic freedom. But then there are really kind of gray areas, and I don't think there are any answers, and I don't know if there could be a constitutional decision because it's so gray. As in the A&M case, limiting the curriculum. That's not telling people what they can and cannot teach. It's limiting what is taught. Now, that's traditionally a First Amendment right, but it seems to me there's a legitimate state interest in curriculum that could limit the curriculum of a public university. Not if it's done for purely ideological reasons, but if it's done for some kind of educational reason. What if a university is abusing its academic freedom by refusing to hire professors who have conservative ideas about certain subject matters, or who are imposing kind of left-wing orthodoxy? I think a state has a legitimate right to be concerned about it, but I do think a state should be very wary about regulating it rather than putting pressure on universities to regulate themselves or waiting it out till universities kind of regain some equilibrium, which often happens. So state intervention in universities, it's always dangerous because it's so often politically motivated, but at some point I think it is justified. And then there are. Gray areas, which I think we both identified.
Yeah, and to just tease out that sort of continuum, right? So Texas has this longstanding requirement for its state universities that students have to take a Texas government class and has to take American government and American history class, but it doesn't specify the content. So part of what's different about the North Carolina intervention lately is it goes further and says, and moreover, when you're teaching this subject, there's certain things you have to cover. You have to include the Declaration of Independence. I think it includes the Constitution. It includes like the Gettysburg Address and like some MLK stuff, right? There's a set of particular things. What's different than both of those, though, from what Florida has done, for example, is that they don't impose a particular viewpoint about any of that material, right? So you have to use the Constitution. You don't have to say good things about the Constitution. Unlike Florida's Stop Woke Act, which specifically is designed to say there's certain ideas we don't want positively expressed in the classroom. We don't want it promoted in the classroom, and so we're going to ban you from expressing a certain perspective on that material. And I think that's an important difference between what North Carolina is doing and what Florida is doing. Trump just the other day, in announcing his orientation toward how to approach higher education in his new administration, has emphasized we want more civics and more Western civilization being taught in universities more generally, and he wants to use the levers of federal power to help get at that. Again, I think if he's focused on the idea of, look, there are certain kinds of subjects you ought to be doing, and we want to see that represented in universities, but doesn't tell you how to talk about it. I think it's going to fall much more in this North Carolina side of that divide compared to the Florida side of the divide. And so there are ways of pushing a lot on universities. I think the trickier thing is if you imagine an example, though, where a state were to say, and we don't want you to talk about certain things in the university classroom, right? So we're not even going to say, there's a viewpoint we don't want to express. We just don't want certain content talked about at all. That has not been tested. I think that's a tricky thing. I think it's probably going to be, from my perspective, on the sort of Florida side of the line of that, of being unacceptable. But I haven't worked through that article yet, so I'm not sure.
Okay, we'll wait for that.
By the
I
way,
do-
the 11th Circuit is going to decide the Florida case pretty soon.
Yeah.
So for those of you who are interested in this subject, which I assume is all of you while you're here, you keep a lookout for that decision, which will probably be decided in the next several months.
Yeah, they've
I-
already done the oral argument on that, and it's clear at least one of the judges on the 3-judge panel was extremely skeptical about Florida. The other two, it's less clear. So
It is now your time
Great.
to ask some questions. I see
What a
some-
great conversation. I just want to let people know that, yeah, put your hands together for this incredible discussion. I just want to let people know online that you can use the question and answer button at the bottom of your screen to add a question. And I would just ask that you all pick from the pre-approved questions that we've provided. All right. Let's start here with Lloyd Kramer. Go ahead.
Thank you. This has been very interesting. I want to say I'm coming at this as a historian rather than as a legal expert. And what strikes me is how you all are so confident that laws and courts can control what's going to be possible. And in the history of societies that we know very well, including North Carolina, political interventions take place whether the courts say you can do that or not. For example, in antebellum North Carolina, you couldn't teach a course in which you would use an abolitionist text. Well, that just was impossible. Couldn't say certain things. So I have two questions. Do you think that in the current context, there's going to be such a push that certain people you can't talk about Gaza in the Middle East in this way? That's just defined as anti-Semitism, and there may not be a legal issue. You're just going to be slammed for doing that. And what about history teachers who teach in high school? We have a very big issue in our state. They're not allowed to say, well, slavery was a major element that brought on the Civil War, things that we might say are true. So doesn't history tell us that law is pretty helpless against authoritarian political movements? And what about high school teachers?
yeah, so I have a lot of interest in the power of courts as part of my other work in general, and how important and influential courts are. And I'm certainly with you in thinking there are limitations to the extent of judicial power and how strong of a protection it can be under some circumstances. On the other hand, I think we're still in a space in which there's a lot of room there for courts to have a lot of influence if they're willing to exercise it. Of course, if courts retreat from it, then it's a different question. But I think there's space to imagine the courts can be fairly interventionist and will want to be fairly interventionist in the space, and it can actually make some significant difference for certain kinds of policies, at least. K through 12, though, may be one of the examples where it doesn't. The courts have not recognized a lot of protections for teachers in the K through 12 context and what they do in the classroom. That is a space that's much closer, although the court has not explicitly characterized it this way. But I think it's given what the court has said on the whole, and certainly what the lower courts have done on the whole. I think what happens in K through 12 education is much better understood as a form of government speech, where the government political actors determine what that curriculum looks like, what the content of the speech is going to look like in the classroom, what viewpoints are going to be expressed. in that classroom. And part of what's important here then is saying not only are professors different than other kinds of government employees, but likewise universities are different than K through 12 education. Because I think it's going to be a losing battle if you want to say, no, K through 12 ought to look like universities. I think the consequence is you're going to undermine universities. And so instead, I'm willing to toss the K through 12 under the
That
bus.
is so not nice.
I agree with the general proposition that there's a lot more at play in society than simply decisions of courts. There are all kinds of historical factors. But a judge can find that a decision by a legislator or an administrator is unconstitutional and order reinstatement. That's a big advance even of what the AUP could do. So courts can be powerful. It's only part of the story, but it's an important part. As to K through 12, basically K through 12, the whole purpose of K through 12 has been treated differently, less to search for and advance ideas and more to teach basic knowledge and even to inculcate societal values. But there are some decisions that see a continuum. I mean, teaching kindergarten is different than teaching a 12th grade AP course, and have the further up you are toward 12 from K, the more a teacher might have something approaching academic freedom. So it's not a like firm divide, but in general, as Keith said, I agree, K through 12 is different than higher ed.
Let's have a symposium next semester on that.
Absolutely.
Yeah.
This is your area, right? This is your area.
You get the scholars, you get the incredible scholars, Mary
And I
Rose.
talk a little bit in the book about some of this complication, right? I mean, one thing that is complicated, I think, about especially the high school context is we have now integrated AP classes and testing, which is pitched as if it's a kind of university. We have these sort of shared arrangements in which people are getting high school credit for taking classes in community college and joint credit across these things. And it really blurs the line between what's university teaching and what's K through 12 teaching in ways that if government officials really wanted to press on that, it would create some, I think, serious complications for how the court would think about, okay, how do we parse out the First Amendment issues in that space?
I have a question here, and I know I have questions on this side of the room, and I also have one online. So we'll try to do a rapid fire. Here we go.
Okay, so social media, the podcast spewing misinformation and disinformation, are they getting away with that because it's just an opinion, it's just a theory and a rumination, but it's still very dangerous. So how do you address that?
Well, I thought maybe to spin that to our panel to talk about professors who engage in extramural speech, because that's something you both have thought a lot about. So the idea that you may have professors, academics who are outside speaking to the public, engaging in misinformation, disinformation, and impacting the public debate. And so how would you think about that?
So one important distinction to make is between whether it's academic speech or political speech. And most professors who use social media are using it, I think, to express general political views, and therefore that speech should be judged by traditional First Amendment law. Whereas if the social media posts relate to the professor's own expertise, then that speech has to be judged by academic standards. So that's an important distinction I would make.
I was referring to non-academic, not professional.
Okay, so that's general free speech. General free speech law applies. Now, there's lots of discussion of whether general free speech law should change in the context of social media. And I would say it's a subject people are debating now. And I would say I don't have expert views about it. I have views about it, but they're not based on my expertise.
And just to be clear, this current state of general First Amendment principles about misinformation and false information and the like in podcasts and social media and whatnot is totally protected by the First Amendment. The First Amendment does not distinguish between false speech and true speech and the like in that context.
Unless
And
it's defamatory.
Unless it's defamatory, unless it has a very specific
But they're very narrow.
But the general idea of can you say things that are false, for example, in a public sphere, that's generally recognized as First Amendment protected.
It sort of seems always comes to be like, what is defining yelling fire in a crowded theater, right? What is the definition of that? But let's make sure we get to more questions. We have an online question. Paul, can you read our online question?
The question is, can you talk a little bit about what protection, if any, academic freedom provides for faculty engaged in faculty governance or service to the university?
So, in my view, academic freedom should protect that kind of speech. Many cases accept that view, and many cases reject it. To me, speech about general educational policy within a university is not as core expert speech as speaking about your discipline. But I do feel, and this is the AUP's position, that faculty expertise extends to general policy issues, and that academic freedom should protect that speech as well as speech within their own disciplinary expertise, as opposed to speech about like how a university should invest its resources. There's no academic expertise about that. That's kind of general expression.
Yeah, and this also is an issue that has a North Carolina connection. So there was a recent federal circuit court case involving a professor at State University of North Carolina who was disciplined by his university as a consequence of his speech in department meetings and in other faculty governance context, in which he was in disagreement with the direction the university and his department was going, and eventually his colleagues shifted him out of the department as a consequence of those ongoing disputes and his vigorous questioning of job candidates and the like, for example. And the federal circuit court said, not constitutionally protected. You have no First Amendment interest in that particular context. I think that was probably wrongly decided, but it's a very much an open question, I think, within existing First Amendment doctrine. And the other thing that's interesting about it is, I think the traditional AUP sort of 1940 statement, for example, principles and lots of university policies about this are highly ambiguous about the degree to which that kind of speech is protected. I've got an article coming out on this case and these issues, arguing that both our policies probably ought to be revised to provide more robust protection of speech in those contexts, and that there's at least some aspects of that kind of speech that falls within the logic of the court's academic freedom cases, such that we ought to recognize it as being First Amendment protection, such as the circuit court got it wrong on this.
Great. And we have questions on this side of the room. I see your hand up there. We'll go to Sam Jackson and then see a question on the other side. Sam.
I'm thinking of a situation where the professor is making rather rude and insulting remarks towards students in her law or social policy class, and the private university disciplines her. Is that an academic freedom issue, obviously more than a First Amendment issue, or is it a competence issue that she's sort of stepping out of her role as a capable teacher by opinionating so much?
If it's a private university, it's not a First Amendment case again. That speech could be unprofessional. Depending on the details are important, of course, but it could be unprofessional, and unprofessional speech is not protected by academic freedom as a professional norm or as a legal notion.
And I think you would have peer review decide.
In the first instance, yes.
Yeah. And do you want to add anything?
I think that's the right approach, and so there's certainly the details will be crucial in this, and there are versions of this where there's clearly would I think fall outside the protections of academic freedom, and so and moreover, we see some university policies and in some cases requirements of statutes. So some versions of this follow afoul of sort of university policies about bullying, for example, but also in some contexts, you see this playing out in the context of that's racially and sexually harassing of students and the like. And we've seen versions of this where professors want to defend themselves and saying, "Oh, this is just my tough teaching style," and courts, for example, wound up looking at that and say, "Yeah, in this particular case, that tough teaching style is not going to be protected because it's just harassing."
There was the Merriweather case dealing with the pronouns, and that's, maybe germaneness comes into play. You mentioned in your book that perhaps it's not germane to the expertise of the professor to weigh in on the pronouns.
Yeah, which is why I think, again, I think the details are going to wind up mattering in this
Yes.
case. So the Merriweather case, which the court, in this case, a circuit court applied sort of what I think is a kind of fairly standard First Amendment kind of analysis, and probably not sufficiently nuanced about the academic freedom components. But the university had adopted a rule requiring faculty to use the student's preferred pronouns in addressing the student. The professor refused to do so, although there was some factual details that complicate that exactly, and a lot of back and forth between the university and the professor about it. But just to assume that for the sake of argument, for the purpose of the court, and at least the circuit court wanted to say the choice of pronouns by the professor was First Amendment protected in that context. But again, you can imagine versions of that where that would probably come out differently, not just in even in the same panel, for example, depending on exactly how it was done by the faculty member.
Well, okay. Thank you. I have, leaving Florida, we lived in Florida and so heard about the anti-woke every day. And I'm wondering about the professor's pushback in the context of public health, for example, during COVID, when scientific data said X, and then the professors were there were consequences to professors, and also having them register whether Democrat or Republican, and then having their tenure being affected and impacted based on those decisions too. So what consequences that has had and where that currently stands.
So on the latter point, I don't know that Florida has done anything that requires professors to identify themselves. So Florida did adopt a rule requiring for there to be some intellectual climate surveys on campus among both students and faculty, asking them a series of questions, which have become kind of common in general about what do you self-censor, and do you feel pressured on certain kinds of ideas, et cetera. And as part of those surveys, they ask also, what's your, what political view do you hold? How do you characterize yourself, conservative, liberal, or are you Democrat, Republican, blah, blah, blah. But those are anonymous surveys. They're designed to be anonymous surveys as adopted in the law. Some of the advocates who were opposed to that policy being adopted characterized them more in these terms, but I think it was a mischaracterization of the policy that was being adopted and applied in that context. And I think the university would run into real trouble if it became more explicit about actually requiring professors to identify themselves as conservative, liberal, Republican, or Democrat, and moreover start basing hiring decisions on this. I have another article going out about diversity statements, and I think and what First Amendment issues are created by diversity statements, and I think the First Amendment issues created by diversity statements are the same ones that would be raised by this kind of issue. Actually, is that you're asking people for irrelevant job qualifications that are politically, say, it has First Amendment implications in making hiring decisions in that context. But again, I think a gray area, not entirely clear, even in the context of the diversity statements, or I think even if you were to say explicitly, no, we're not hiring any more Republicans, or we're not hiring any more Democrats to our faculty, or conservatives or liberals or whatever, right? I think there's some genuine gray areas there about how current doctrine would cash out.
And those are free speech issues, not academic freedom
Yes.
issues, whereas the climate change point might be an academic freedom issue if the person speaking about climate change was professionally expert in that subject.
You must have a lot of Word documents. At the same time.
I have quite a few things coming out of this. As I said, there's a lot of interesting issues that now are suddenly on the table, and it's important to think them through.
We're getting close to the end of our time. We have a question here. I want to remind folks on the online audience, if we have quick questions, we might be able to take a couple more.
So at UNC, we're seeing the state impose a curriculum that is going to expose students to both conservative and progressive viewpoints. So as an extension of the climate change issue, what happens if a conservative viewpoint is that climate change is a hoax and we're going to teach a course? Now, this doesn't hold up to academic standards. So can you discuss that? Because I did attend a seminar a few weeks ago, part of this curriculum talking about election fraud, which really doesn't exist to a large extent based on scientific studies, yet an hour and a half was spent talking about election fraud.
Yeah, I do think that you potentially run into some real First Amendment issues. again, I think it would be a close question. I don't think it's obvious how courts would resolve it. But I think there's a genuine First Amendment issue to be thought through about if, for example, policymakers were to mandate professors to teach things that we would think were professionally incompetent. For example, the misinformation and you're being required to do it. So the Indiana intellectual diversity law, for example, that I mentioned, I think specifically does not do that. Although a lot of the critics of the law thought that would be the implication of the law. But the law doesn't specify exactly what ideas have to be taught, it just says you have to have a range of ideas. And so it does, and whereas you can imagine a version of that, though, on the other hand, that says, no, we want you to actually convey this idea that we politicians favor, even though you academics think it's all hogwash. And I think that'd be tricky, but I think there are genuine First Amendment issues there.
I don't think it's tricky as a matter of theory. Who knows what a court would, it's clearly a violation of the First Amendment right of academic freedom of professors and of universities to require teaching of theories that do not meet academic standards among academic experts. Now, what counts as within academic expertise, I believe, should be broadly construed. People should bend over backwards to, hear the possibility of views different from their own. But if there's really no support for it within a field at all, really at all, it's a violation of academic freedom to require teaching it. If there's no academic support.
1% support among scientists or 2% support. Is that something that holds up to academic standards?
So we don't have case law on that. This is unclear. In my view, but it's personal, it's not law, it shouldn't take much of a percentage of people within a field thinking it's within academic standards to include it as within academic standards. It's dangerous to exclude, but some things there's really no support for. Some of you may know better than I. Homosexuality was considered a disease by the American Psychiatric Association and the American Psychological Association into the 1970s, I believe. I think today psychologists and psychiatrists would consider that view to be the equivalent of the earth is flat. So views change, but I think it's important for universities to be open to views, particularly controversial ones. So it shouldn't take much academic support to include it. But at some point, there isn't enough.
And there's the mandate issue adds an interesting wrinkle here, but also there's a question about, again, think about the flip side of this, of instead of focusing on sort of a mandate of your being required to teach things that you think are wrong, but maybe 1% of your discipline think are wrong. But what if you want to teach the thing that only 1% of your discipline thinks is correct, but most of your colleagues think is wrong? Do you have academic freedom protection in order to do that, both under questions of professional norms, but also potentially under First Amendment law? I think the answer is yes, but again, it may depend a little bit on how you're teaching as well, right? Are you teaching as if everybody agrees with this? Or are you presenting fairly to the students to say, okay, this is the minority posture, here's what everyone else thinks, right? This is a viable theory that I also want you to be aware of because I and a handful of other colleagues think it's the correct one, for example. I think that ought to be protected, but there are versions of that maybe not so much.
Well, we are over time, but it feels awkward to cut off a question in a free speech panel. So we're going to have one more question here. Brent.
What are the two general categories of cases that come up most commonly?
Under academic freedom?
What are the most common types of cases that come up?
The most frequent cases are not ones that raise the most important academic freedom issues, it seems to me. The key academic freedom concern is freedom to teach the content of one's expertise. I think the greatest number of cases, I'd be curious to hear what Keith has to say about this, involve like disputes within the university between professors and administrators, often over like stupid stuff. But arguably, you know, it's protected as discussing educational policy. So I would say, you know, the greatest number of cases are those kinds rather than the cases that really raise fundamental issues of academic freedom. I hate to give that answer, but that's my impression.
Yeah, I would just say, I think the most common kind of case that more clearly it's sort of within the range of things that we think of as, although I think David would say not truly academic freedom, but free speech things, are the extramural cases. So professors talking about politics in public because of the rise of social media. There's such an easy opportunity for professors to give their unvarnished views without gatekeepers to the wider world, and the wider world hates that and pushes back. And so we've just seen an explosion of cases about those kinds of issues now. And those are sort of core kinds of things that are protected by these traditional, both First Amendment protections, but also free expression and academic freedom policies on campuses.
Well, time flies when you're having fun, doesn't it? Right? It really does. Well, let's put our hands together, Keith Whittington, Dahr, Rabban, and for the unparalleled Mary Rose Papandrea putting this whole thing together. Mary Rose, want to tell anybody about what they might be able to do at the symposium? If there's any other public events, for remind folks what's going on Friday.
Just for those who were joining us late, I mentioned at the beginning on Friday, the law school, UNC Law School is hosting the First Amendment Law Review Symposium on free speech in universities. It's a day-long affair. We will have 3 different panels, one on students and protests, one on faculty and academic freedom issues, and a third on institutional leadership. It's going to be fantastic.
I'm glad to hear that about students, because if there was nobody asking a question, I was going to ask about students. So again, put our hands together for our wonderful panel. Thank you all for coming, and thank you for making this a wonderful semester here at Carolina Public Humanities. What a wonderful way to close out. I will remind folks, we'd love your opinion, so please scan the QR code, and you can write whatever you want later if you want, but get it on your phones if you would, and we'll see you all next semester. Thanks so much.